safe community. Ongoing developments in public safety, law enforcement, and community justice.
Child abuse cases are some of the most challenging types of cases to prosecute, both due to the nature of the vulnerability of victims and because evidence and testimony is difficult to acquire and can be scarce. At this month's local Public Safety Coordinating Council meeting, Senior Deputy District Attorney Lucy Durst gave an overview of how child abuse cases are handled and prosecuted in Jackson County.
There are 4.3 million children referred to CPS, which is Child Protective Services in the United States. 28% of those become screened-in reports. There are just over 500,000 victims of abuse and neglect nationally, and an estimated 1,700 children died from abuse and neglect in this calendar reporting year of 2024. Of those victims, we're dealing with a really vulnerable population. Not only are they children, but close to 36% of them are 5 years and younger. I'm assigned cases involving both physical and sexual abuse of children under the age of 18. So the role of the district attorney's office specifically, we review police reports as well as DHS reports. We work with law enforcement and child protection agencies. We make charging decisions by applying the facts of a case to the specific charges under our ORS. If it's a felony case, we're presenting the cases to the grand jury. Another important part of our office is with victims' rights. And then also in our role at the DA's office, if it's charged, moving forward to a case resolution, whether by negotiated agreement or a trial. Again, our office at the point that we're receiving it is receiving reports directly from law enforcement who has received them from DHS, other mandatory reporters, family members, or community members. And then they are conducting the investigation to include interviews or evidence collection. That's oftentimes in conjunction with our conversation about what types of things we should pursue. And then just on the right here, all of these entities and people, SROs, family friends, DHS, really work together. And when those parties all work together, that is when we are really able to make a difference preventing child abuse. Factors unique to child abuse cases compared to other cases. I'm primarily relying on a child's statement to prove my case. Of course, sometimes I have physical evidence like a DNA kit or a sexual assault kit. Sometimes there's a witness, but oftentimes there's one witness to the abuse, and it's the offender. The reason for that is the offender is the one choosing to inflict the abuse. They are the person solely in control of when and where this happens and who might be witness to it. Lack of physical evidence, developmental ability of a child to testify, the timing of a disclosure. So this primarily is a factor in my sex abuse cases. Who did the child first talk to, under what circumstances, and why did they decide to speak out now? I'd say the majority of my cases are not an instance of sexual assault of a child that happened and they report it immediately where physical evidence can happen. It's, maybe a 6-year-old saying, well, we moved in next to my aunt and uncle, and my aunt and uncle have a 6-year-old, and I don't want what happened to me to happen to them. So you're asking a maybe 10-year-old to talk about something that happened when they were 6, relay that back in a specific statement, not saying this is how it always happened, but this is how it specifically happened in this one time. Victims' fear of negative consequences. Sometimes victims recant. Sometimes what we see is a child will say, well, I tried to tell my mom and kiss me, and my mom kind of brushed it off. And so the child doesn't go on to disclose more because in their mind, from their perspective, they attempted to reach out and disclose, got shut down, didn't think they were believed, and then they don't report further. In 1 year, I had 251 cases referred, 134 cases charged, 306 cases were disposed, so it could have been cases from the previous year that then resolved, and I had about 6 trials. No 2 cases are alike, and it's really trying to find that balance of holding this offender accountable to the extent allowed by the law to protect society from this person, but also finding that sense of justice with the victim themselves. My victims in my cases, they don't get to choose that they were victimized. I always let them know I'm going to use my training and experience, my past history, that their only job is to be honest about the case, and in return, I'll be honest about any strengths or weaknesses. I don't want to take that choice away from them. It's not up to them to resolve the case, but it's also one of the few pieces of this entire process that I like to give them autonomy with, because they didn't choose any of this, and there's nothing I can do. 100 years in prison, which I can't actually legally do, but there's literally nothing I can do that takes it away. So we really like to make them feel heard, and usually, but not always, through conversations about strengths and weaknesses or what this might look like or not look like. By the time we're at the end, they feel heard and satisfied, but it just does lead to different resolutions because each case and each child and each set of facts is different.